Hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this live legal education content, and today will be the day that I earn your subscription. For today's live stream, yes, we're a little bit late to the party, but we are finally getting around to the drama that is infesting our friend Nick Rekieta. Nick Rekieta, as many of you know, runs the increasingly successful law YouTube show, Rekieta Law, where he acts as a degenerate, or maybe doesn't acts is the wrong word because I've met him in person. Just is a degenerate with a law degree, and he's fun and he engages people and he drinks and he's everything I hope to be when I grow up. He's everything I hope to be when I grow up. I love the man so very, very much. And one of the things that cracks me up the very most about this entire saga is I look at law and crime and I'm like, really? Really? I mean, let's just put aside all the legal arguments for just 1 second. Really? You're getting salty over this degenerate? Really? You know, you could just, outcompete him. It's not like he's doing anything super magical. He has a camera and a microphone, and he has a safe in a basement that he broadcasts from, and he drinks. There's nothing up his sleeve, and then he invites a lot of us on who, as you may or may not have noticed, none of us are exactly working with professional backgrounds. But somehow we are kicking the ass of law and crime. Now, law and crime could use this as an invitation to clean up their own room, but instead they're going to be salty. There are two ways. There are two ways to build biggest tower. One way is to build the biggest tower. The other way is to burn all the other towers down so that yours is the biggest. Guess which of those two options that law and crime thinks is the best one. Should we just build the best tower? Should we just build the best tower so that people will come to our tower because it's pretty and wonderful? Or should we burn down everyone else's tower so our miserable, sad little tower is all that's left? Our pathetic, nearly limp little tower. We're going with option number 2 over here in Law and Crime Land. So we're going to cover this. So let's do that. We will start with a memo from Law and Crime, who has a fancy network logo and has a fancy network address in New York, New York. So, they could just not suck. There are 0 things preventing Law and Crime from doing exactly what Nick does. Even better, one might argue. 0 things. But they just want to complain about other people's success. Covet not your neighbor's ass, and so forth and so on. Via email. Attention, Mr. Rackets. I am an attorney for Law News with a Z, so I instantly take you more seriously. Doing business as, and hereinafter referred to as, Law and Crime, which owns and operates the Law and Crime Network, a 24/7 live television network focused on live trials, legal analysis, and legal news. I'm no expert, but I would imagine running a 24/7 network with staff and producers and videographers and sound people and so forth and so on might be a fairly complex operation. One would think that you could find a couple degenerate lawyers to, drink bourbon on one of your shows, but apparently no. You can't find the degenerate lawyers in New York. You can't find a ragtag bunch of lawyers who are degenerates in New York to drink and possibly swear on your 24/7 news network. Maybe you don't think that would be good for your brand. Okay. It's good for Nick's brand, though, and he's succeeding, so just saying, it's an option. Have you just considered doing that? That's a choice. Just a friendly tip. You could do that. It has come to our attention, just now, I'm sure, that over the course of the past couple months and perhaps beyond, you have repeatedly posted on your YouTube channel entitled Law with Rackets a multitude of live streams that contain, in whole or in large part, law and crimes copyrighted law feeds. You say the word copyrighted. We'll get there. They're live feeds. Whether they're copyrighted law feeds is by no means assured, as we will dig into this, of various court trials and related proceedings. Let's just go ahead and give you the spoiler on the whole copyright thing. One of the principal aspects that copyright only extends to an original work of authorship. Original work of authorship, you need an author. You know what Law and Crime is not doing? Producing the trial. The trial is being produced by, the judicial system. They're not scripting the lines or telling the people how to act or emote or writing the objections. Or if they are, they're doing a really shit job of it. But, they're not staging the work. The work is happening, regardless of their efforts. So one of the first questions you might ask, in fact, the first question you probably should ask, is there an original work of authorship? In what sense or senses is Law and Crime an author of the work? They're not controlling the people. They're not controlling what's said. They're not controlling the judge. They're not controlling the gallery. There's some problems, just saying. It's not a produced work. Yeah. Please be advised that due to your publication of the infringing content, debatable, we'll get more into it, on your channel, you are responsible for infringing of certain copyrights that are owner controlled. Well, at this moment, none of those copyrights are registered. So, there's that. You want to go lie to the copyright office or whatever, have fun. Incidentally, you can't sue until it's registered. It's actually a feature. You literally can't sue until it's registered. So there is that. Yeah. Nick might be able to sue you for declarative relief, though, but you can't sue him. You are infringing on certain copyrights that are owned or controlled by Law News. Law News, therefore, demands that you immediately cease such infringing activity by removing all such infringing content existing on your channel or on related platforms otherwise owned by you or associated with you. Desist from such infringing activity in the future and comply with Law News' other requirements set forth in this letter. Nick has said no, perhaps unsurprisingly. It is not clear that there is any infringement in the first instance. We could get into a fair use analysis, and we'll get there eventually. But to even get into a fair use analysis, we first have to decide whether or not there's a copyright. That's kind of a more critical step one. To illustrate the Rackets LawTube channel publication of the infringing content, by way of one example of many, on January the 5th, Mr. Rackets himself live streamed opening arguments for the Chandler-Halderson trial. Ooh. Which infringed live streams containing over 2 hours of Law and Crime's copyrighted live feed on the same opening arguments. As you are aware, Law and Crime's infringed live feeds, they keep using this word, are copied directly onto the Racket's LawTube channel. And most of the time, the trademark logo can be seen in the bottom left-hand corner of the infringing content, leaving no doubt the infringing content infringes on the copyrighted work. That's not how that works. That's not how that works. Your logo doesn't prove that you own the thing. You just because you put your sticker on it doesn't, by and even of itself, mean it's yours. You know? Sorry to break it to you. Just because you put the Law and Crime logo does not mean it's mine. This is the meme with the guy looking at the butterfly. Be like, is this mine? You're like, yeah, I don't know. Law News cannot and will not accept infringement on anything it's intellectual property. Incidentally, they can, just by way of issue. They can. They absolutely can. There's not even prejudice to them, like there is in a trademark area, right? In trademark, you can potentially run into a problem, although this principle is a bit over-applied, to be honest. But at least there is a principle that you can lose your trademark by other people's improper use. It ultimately can result in something we call genericide, where your mark becomes so diluted that it ceases to be. This can happen. This has happened. All right? So there is some obligation to police your trademark. Now, most companies take this obligation a little too far, or maybe a lot too far, to be honest. But there is a principle. There is no such principle in copyright law. It doesn't exist. You can allow 1,000 people to infringe on your copyright. It does not weaken your copyright interest. There's not that same doctrine that there is in trademark law. There's no equivalent concept in copyright law. If 1,000 people start rubbing off, and if you think about it from first principles, it makes sense as to why. If you think about it as the first principles, it makes sense as to why. What is the fundamental purpose of trademark law? What is the fundamental point of trademark law? To determine the origin of the goods. That's the fundamental purpose of trademark law. Where is the thing coming from? It's ultimately a consumer protection measure. The consumer sees the label, they see the trademark, and they know and can have confidence that that is authentic. And regardless of what they think about that mark, for good or ill, all right? So it doesn't necessarily mean you think it's good, but you can be assured it comes from that supplier. The fundamental purpose of trademark law is to protect the origin of goods for the consumer. That's its fundamental underlying purpose. So if everyone in the world starts putting your logo on all the things, it ceases its fundamental purpose. To alert people as to the origin. It no longer serves the purpose of telling people the origin. So it's no longer a trademark. In fact, it's no longer a mark of trade. Trademark, mark of trade. See, you know how that works? Yeah, okay. So that concept doesn't apply in copyright, because the right is in the nature of the right to copy, not in the right of trade. And other people copying does not, while it may infringe on your rights, it does not dilute your rights. So they can, I'm just saying, they're lying. I don't know if they know if they're lying, but they're lying. Law News cannot, yes they can, and will not accept infringement of any of its intellectual property, including its copyrights. You definitely could, if you own them, which is dubious. Not saying it's impossible. I'm saying there's some doubts. Right? In the interest of any defamation issues, in this entire discussion, I've never said that they don't have a copyright interest. I've said it's doubtful, dubious, shaky, questionable, thin. There are some doubts. It's not clear. Right? I'm not defaming them. I'm not saying they don't have it. But, you know, I have some doubts. We'll get into why. We'll do the analysis as to why. Yeah. The ultimate question is one of legal opinion, too. So, there's that. It is an opinion question, a legal opinion. I'm writing a legal opinion letter as we speak. RL's YouTube channel is currently using far more than Law News Inc. or any court would allow. Questionable. Also, the amount of use, when they say using far more, right? When they're saying using far more, that sounds like a quantity argument, right? You're using far too much of our work. Well, that's one of the 4 factors when it comes to fair use, which requires an underlying copyright, which is questionable. The amount of the work, it's one of the 4 factors, right? And you could, and there's, you know, you can use, at least theoretically, you can use 100% of the work and it be fair use, because there are other factors in the fair use analysis. Right? So, will a court let you use 100% of the underlying copyright work? They might. What else is going on? There is no strict quantity limit. It's a balancing test. Your use of the infringing copyright does not fall under copyright's fair use, which might, in the very technical sense, be true, because it can't fall under fair use if there's no underlying copyright. So there's that, I guess. It doesn't fall under copyright fair use as the quantity of the information used by you is not limited to a short excerpt as being commercially exploited by profit. That's the purpose, the nature of the work is another factor. Hey, you got 2 for 4. Law News has reserved all of its rights in its work under copyright, which again, you could choose not to do. You could. And has not authorized you or RL, the Rackets LawTube channel, to reproduce, publish, provide, distribute, transmit, display, publicly perform, or otherwise make use of the works. Therefore, RL's YouTube channel use of the work is a clear infringement of the copyrights in violation of sections 106 and 501 of the Federal Copyright Act. 106 requires it to be, among other things, an original work of authorship, which is not obvious. Law News Inc. treats its copyright infringers as a very serious matter and fully enforces its rights under infringers. Okay. I mean, that's an option. You could, you know, just produce your own program, better program, but this is an option too, I guess. Please also be advised that the infringing use of content is an explicit violation of YouTube's live streaming policies, which are based on copyright law, so you know. It's increasingly important that you understand the majority of Law and Crime's live feeds that the Rackets Law YouTube channel uses in its infringing content are privately owned by Law News Inc. and are not part of a pool. That doesn't seem to be true, as we will see shortly. It seems to be a bit of a lie. We will see if it is or is not a lie based on other things. Is it a pool or not? Well, we can look to the court's order that might suggest whether or not it's a pool. It might be a lie. We'll see. Let's look at what the evidence says and see if it's a lie or not. Could be. I will show you the evidence, and then, you know, you can form an opinion as to whether or not that's a truthful statement or not. Yeah. Any other individual or entity that seeks to use such privately owned content must first obtain explicit permission from the law. This distinction must be introduced by you. It is also alleged that various subscribers and or supporters of Mr. Rackets Incorporated have either spammed Law Crime's YouTube channel chat or put into YouTube's chat channel various comments referring them as retarded and mentally disabled, as well as other unacceptable comments. This is unbecoming, intolerable behavior is supplemented by your own choice of words on your live streams while referring to law and crime as fucking pussies for having removed your live feed that you were infringing at the moment. Okay. Whether or not you are fucking pussies or not is in fact a matter of opinion. And we do have this thing called the First Amendment. You cannot go into court and say, we'd like a declaration that we're not fucking pussies. We'd like that as a factual determination. Could you ask the court, could you ask the jury to determine that we're not in fact fucking pussies? I'm not seeing that one. Not seeing that as a declaratory cause of relief here. So Nick over here has the First Amendment. And, he's required to have any opinion he wants, or he can have any opinion he wants, and he can express it any opinion he wants. It's his opinion. I've never seen Nick encourage on his channel, not that I've seen every single moment of his channel, but I've never seen him direct or encourage anyone to go and anyone else's stream and say things. He's offering his opinion. And if people acting independently of Nick also want to offer their opinion, potentially to you, there's that. Presumably you don't mind it when people come onto your channel and say nice things about you, right? I mean, you like that. So. Although you may not be responsible for the actions of your subscribers, he is not. To the best of my knowledge, he has never commanded, extolled, incited anyone to go over to your chat and say mean things. He simply expresses his opinion. And some of us listen to it, and some of us are persuaded by that opinion and share that opinion. And I guess some not as well, because, although you're not responsible, you are responsible for your own behavior. Which, yes, I suppose, but... And your unprofessional, unseemly, and misguided comments towards law and crime directly influence and encourage your subscribers. No, they don't. Unless you think in some alternate universe, if he were saying nice things about you, that would directly also encourage them, which presumably you'd have no problem with. But I suppose it might influence them, but it doesn't encourage them to engage. That's an independent decision they're making. No. In the aforementioned repulsive behavior, which is not illegal, Nick is not trying to harass you. Nick is not directing anyone to harass you or disrupt you. Never seen him do anything of that kind. Never heard him do it. I've heard him say exactly the opposite. He's not encouraging anyone to go onto your channel. Neither am I. Just expressing an opinion. If people independently want to express their opinions, that's part of freedom of speech. I'm sorry you don't like those opinions, but and incidentally, you don't have to tolerate it on your own channel. You can moderate it. You have moderators. You can moderate it out. You could close up your channel or close off your comments. You have lots of options. You don't have to tolerate it. You can control your own channel. Go nuts. This behavior is further encouraged by your tweets directly at law and crime, which tweets contain false information often lead your supporters to spamming. What is the false information? Please tell us the nature. What is the false information? What is false? What false fact has Nick shared? I'm sure if you told him, he'd be happy to correct it. Sometimes we get it wrong. What facts have we said that's wrong? We'll correct the record if we make a mistake. It happens to the best of us. Despite all of this, Law and Crime is prepared to try to resolve this matter amicably. Nick doesn't seem that interested. Provided that the Rackets channel cooperates fully with Law and Crime and establishes to its satisfaction that Nick Rekieta's publication of infringing context were errors in judgment. I don't think he's feeling that. And not a systematic effort to profit from long intellectual property. We'll get to the intellectual property component of this. We therefore request that the Rackets channel and other associated platforms do the following. Immediately cease and desist all other further productions, reproduction, publishing, and displays of material that infringe on our works. Destroy all such infringing materials in its inventory or in its possession or control, including all copies in electronic or printed form. Immediately cease and desist from any direct or indirect encouragement of your subscribers. He's never done that, to the best of my knowledge. Immediately cease and desist from any directed or indirect defamation. I don't know that he's ever done that either. If he's made a false statement of fact, please let us know. And I would imagine, I mean, obviously I can't speak for Nick, but I would imagine if he made a mistake of fact, he would correct it. He probably won't change his underlying opinion, but he's probably more than willing to correct any actual factual mistakes. I would think. So, you know, you could let us know what those are, and we'll be happy to correct the record as we're calling you fucking pussies. Sorry for the, yeah. we must retract our prior statement of blah. We apologize to the fucking pussies for our misstatement. We regret the error. You and Rikita Law's YouTube channel are specifically advised that any failure or delay in complying with these demands will likely compound the damages for which you and or Rackets channel may be liable. Accordingly, blah, 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 blah. Signed, Eric Slater. Now, I will not disparage Mr. Slater. He is doing the work of his client, who presumably has authorized this, quite possibly against Mr. Slater's advice. I don't know that for sure, but it would explain a lot. Mr. Slater is doing, he is a brother in arms. I can only hope that he secretly knows his client's full of crap, but he's going to represent them the best they can, as he should, as a lawyer. So, you're welcome, at least on my channel, anytime, Mr. Slater. In fact, maybe I should reach out to Mr. Slater, see if he wants to appear on this channel after I said mean things about his client. That could be hilarious. I'll reach out, I'll send out an invitation, Mr. Slater, say, hey, do you want to appear on YouTube after I said that your clients are a bunch of pussies? And tell me why you actually do have the intellectual property. See if he wants to respond. And maybe he can school us all. Could happen. Could happen. All right. Could I repeat that? All right. So now let's read from Nick's reply. This is from Smiths and Associates, which also has a fancy logo. This is Nick's attorney. Dear Mr. Slater, I have the pleasure of representing Mr. Rikita with regards to the issues raised in your January letter. Now, one could parse that a couple different ways right off the bat. I would like to take note. I have the pleasure of representing Mr. Rikita, or I have the pleasure of representing Mr. Rikita with regards to these issues. Maybe less with regards to Mr. Rikita himself. A couple ways to parse that sentence, I'm just saying. In short, your letter seems to misrepresent the factual situation, while not citing any substantive law. Absent additional information and proof of your claims, as requested below, Mr. Rikita will not be taking any of the actions set forth. We're going to want you to show your work a little bit on that one. Finally, as described below, should you take additional actions by filing a DMCA takedown request to copyrights that you almost certainly do not own. This, again, is Nick's lawyer's opinion. Mr. Rikita will respond with a 512F action, which is basically would let him get attorney's fees for the false use of the copyright. Mr. Rikita is a popular online personality who provides insights. That's That's a really dubious proposition. And commentary on pending legal matters and issues on his legal channel. As part of this, Mr. Rekieta will occasionally show live streams, in-court video, and provide commentary and criticism of the legal proceedings being shown. In short, you assert the following. It is increasingly important you also understand the majority of Law and Crime's law feeds that Racket's live channel has used infringes content are privately owned by the Law News Inc. and are not part of a pool. An individually and or entire entity that seeks that seeks to use privately owned content must first obtain explicit permission from the too cool for the normal law people, too cool for the normal law news. It's law news with an edge. This distinction must be understood by you. However, you've provided no proof of this. What must be understood by you is that Mr. Rekieta's streams show only the in-court footage. They do not show or use any of the editorial or other content. Yeah, you could have your own drinking law show. You know, it would be fine. You provide only one specific example, the Chandler-Halderson trial. Enclosed herein is the court's order with regards to the video feeds. As the order states, only 3 cameras were allowed in the courtroom. Is it your contention that those cameras were owned and operated by Law and Crime's employees or agents? That seems unlikely, especially given other press coverage and live streaming of the court's video. It seems more likely that Law and Crime is using the video from other news outlets, just as Nick is doing. Which, you know, seems to be true based on other feeds that are available at the trials. You know. Merely adding your logo to a video you own does not make it yours. Yeah, this is undeniably true. Merely adding it does not, in fact, convey ownership. Please provide proof that Law and Crime is the owner of the copyrights. And here I would have perhaps said better, the author and owner, because I think that's more of a fundamental problem, but, you know. Owner of the copyrights of the in-court footage used by Rekieta that Law and Crimes asserts to be offending. Absent that, no actions will even be considered. Moreover, a search of the Copyright Office shows that Law News is not the owner of any registered copyright, which is kind of weird. I mean, any at all? They've never registered a copyright ever for their entire network? I mean, you know, okay. As you know, a registered copyright is a prerequisite to filing any infringement lawsuit. It sure is. The U.S. Supreme Court cleared that up a couple years back. Given the court's order for the Halderson trial, it's highly unlikely that Law and Crime would even be eligible to register the in-court footage. As the court has explained, and this is quoting from Feist, which we will also read in a little bit of depth to talk a little bit about the claims that are here. The sine qua non, which I think Nick Racket's mispronounced. Which I really shouldn't give him a hard time for mispronouncing things. I mean, me giving people criticism for mispronouncing. I mean, really? That's not a good look. The sine qua non of copyright is originality. To qualify for copyright protection, a work must be original to the author. Original, as the term is used in copyright, means only the work was independently created by the author as opposed to copied from other works, and that it possesses at least some minimal degree of creativity. As stated above, it's unlikely these in-court streams were created by Law and Crime as opposed to some other major and or local news outlet, and it's not even clear that whoever it is has a copyright either. They might, but it's not clear. When we get into the orders, we'll discuss a little bit more about why. This is actually where they say it. There's no degree of creativity in these streams. This is the real problem. This is sort of where it all kind of breaks down. So I guess we'll cover it now. Moreover, there's no degree of creativity in these streams. As the court order shows, it was the court that set up what can be shown, the number and positions of the camera, and where the recording can start and stop. There are no editorial decisions made by the creators of these videos. Yeah, this is kind of the ultimate problem. for their copyright claim is, as the Supreme Court said, in order to be an author, you have to have a minimal degree of creativity from Feist. Okay, where is it? It's not in the lighting. The lighting is just whatever happens to be in the courtroom. It's not in the witnesses. They're not scripted. It's not in the parties. It's not in the judge. It's not in the jury. It's not in the gallery. Right? There's no originality there. So what's left? Camera placement? Well, who's determining the camera placement? You know? Who's making that decision? Right? It seems like it might be the judge. Is it in the focal length of the lens? Is that a creative decision? Or is that kind of a dictated to by the nature of where it's being filmed? Do you always use the same lenses basically every single time in all these hearings? I bet you do. It's not like today I'm going to go for the fisheye lens. And today I'm going to go for the telescope lens. And today I'm going to go for the 110 millimeter lens. You know, I don't know that there's a lot of creativity in the lens choices. Is it in choosing what to film? Don't have a lot of choices there. And also, you know, they're not under your control. So there's not, you know, a lot in it. The camera placement's kind of dictated by the court. The lighting's controlled by the court. The audio's controlled by the court. The lenses are kind of dictated by the position. The placement's dictated by the position. Such editorial decisions, to the extent they exist, are kind of dictated by the flow of the trial. You know, not a lot of opportunity for creative decisions in here. Where is the authorship coming in? You know, it is not clear. It might exist. It's just not clear. The stream is nothing more than a recording of facts of what happened during a public trial. In fact, some courts have explicitly ordered the media to disclaim copyright as a condition, which might kind of be implicit in the nature of the orders. Any assertion that Law & Crime owns the copyright to the video for any other trial, especially the power trial, will be baseless. Your letter also makes a perfunctory attempt at a fair use analysis that misstates the elements. Until we have proof of any actual ownership, I will not spend my client's time going through an exhaustive fair use analysis to content you don't even own. Yeah, you can't have a fair use analysis if you don't have a copyright. Doesn't really make sense. Can't get to section 107 without going through 106, you know? However, even assuming arguendo that Law & Crime does possess the copyright to these videos, as the Supreme Court has made clear, informational works such as news reports that readily lend themselves to productive use by others are less protected than creative works of entertainment. Right. This is what's sometimes called a thin copyright, if it exists. These streams are nothing but informational, factual footage as to what's occurring in a public trial. Law & Crime adds nothing, not even commentary. To these, you could, just incidentally, it's an option. If you want me to come on there and drunkenly ramble over one of your video feeds, let me know. It might be fun. I can sing, or I'll make singing noises. And you know what the best part about having me on? And making singing noises on your broadcast is, you know what the very, very best part is? I am such a poor singer that it can't even be said to be an infringing performance of the underlying work. It's at best some vague homage, so you won't have to pay any licensing fees. Eh? Additionally, the enumerated examples of criticism, commentary, and research are meant to give some idea of the activities the court might regard as fair uses under the example. This is exactly what my client is doing. Making comments and criticisms on a public trial. My client could use the entirety of the stream for the purposes he's using for, and it would be clearly fair use. Could well be. In cringing fits better for you. That's funny. That's good. I like that. My client, yeah. However, it's unlikely you own or are eligible for any copyright protection for these in-court streams. Thus, the analysis is moot. You make one final assertion that Nick the Ricada tweets consistently contain false information. However, you provide no examples, which would have been really helpful. Which bolsters our belief that there are, in fact, no defamatory statements. Yes, you know, if he tells you to suck a bag of dicks, that is not a false information. Like most of the letters, simply appears you're making broad, unsupported statements in an attempt to bully and silence an independent creator, in an attempt to be salty. Absent any specific examples of defamatory content for which we believe there are none, we'll take no actions. Finally, this letter serves as notice to you that Law and Crime does not own the copyrights to the in-court footage used. I would have written that slightly softer. Likely does not, but yeah. Does not own the copyrights to the in-court footage used by Mr. Ricada, and even if it did, Mr. Ricada's use is fair use. Should you consider filing a DMCA takedown notice, you'd be likely perjuring yourself and exposing Law and Crime to civil liability. Probably less with the perjury, though, because the standards are unfortunately really, really low. But with some sort of copyright abuse, cross-claim looks better. Given the size of this filing on YouTube, the damages from a false claim would be substantial. They very well could be. Nick makes a surprising amount of money from these streams, which he does not share with the other children. Should you make any misleading or false claims of these videos, Mr. Ricada will respond with a lawsuit. Absent proof of ownership in the streams, your demand fails. Further, and even assuming arguendo, you did possess copyright, Mr. Ricada's use is clearly fair. Your other assertions are baseless. Blah, 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 blah. Provide us proof and go suck a bag of dicks. All right, so let me read some super chats that have come in from you guys as we have been talking. And would you like to guess what the what the bot has not been doing? Anyone want to take any guesses? Okay. Let's find out your super chats by doing it the hard way. $1.99 from Johnny Stoffel. Ellen sees the dinosaur with umbrella as meteors fall. $10 from John Doe. Thank you for everything, sir. Keep doing what you do. Well, thank you very much. $4.99 from Sam Walders. I work in video production. The hurry pull probably comes from court employees who then distribute the media. This is in no way an artistic work. Yeah. Stuart Tamanana. From $4.99. Wasn't his father, Floyd Abrams, a famous First Amendment lawyer? Could be, I don't know. Mike the Dad Crosby, $10. LNC indicated their feeds are not pool. We'll get there. Nick read the court order for most of the trials he's covered, and the orders from the judge have labeled these feeds as pool. Yeah. $1.99 from Conservative on Campus. What law do you practice in your day job? Patent law is my day job. And Mithrin Emrys, and just for the record, none of the opinions, because this is kind of somewhat vaguely close to my domain of practice, none of the opinions expressed in this video represent the opinions of my employer, which I wouldn't normally make the point of saying, but since it's somewhat tangentially on point, why not? Yeah. $20 from Mithrin Emrys. Hey, Uncivil, glad to catch you live. I went dark side and took a job as a prosecutor. Already had and won my first jury trial. Nick is right. Working for the state is playing law on easy. Well, congratulations, Mithras. Try to remember to only prosecute the guilty, and that would be very much appreciated. Lord, have mercy. $5 from Aliel, thanks for the read, and $50 from Mike the Dad Crosby. Nick's cut I was going to super chat him tonight. Try to spread the wealth grin. Well, thank you very much. I do, as always, appreciate it. Lord. All right, so let us read on. Now, I thought what we do is we could start with the Halderson order, because that's the one that Law and Crime bitches about. Excuse me. Pardon me. We'll cover this because it's the one that Law and Crime bitches about. So here's the order from the Halderson trial. The above caption matter is scheduled for jury selection and jury trial commencing on January 3rd. The court is mindful of the need to balance the right of parties to fair trial with the public's right to access. After considering this balancing and after hearings and consultation, the court enters the following order. Pursuant to rules, video cameras will be permitted access to the media room adjacent to the courtroom. These cameras will be subject to any restrictions set by the court. Because media room has limited space, no more than 3 video cameras may be used at one time. The media is encouraged to cooperate in the video process as no additional cameras, still or video will be permitted. It sounds suspiciously like they're being encouraged to, I don't know, pool. $5 from LD. What was your favorite made-up word today's trial? I don't know. And $10 from Anti-Commie. Can you imagine giving someone free content in their lane? So yeah, it sounds like, these cameras are only going to be permitted, so you got to cooperate. So it sounds suspiciously like a pool. Also, were they Law and Crime's camera? Were they being run by Law and Crime? Who was actually behind the camera? Kind of would at least partially matter. But, you can only, The cameras may be used to capture images of counsel, the defendant, counsel tables, the witness stand and witnesses, the screen upon which exhibits are shown to the jury, the bench, the wall of the courtroom between the bench, counsel tables, and the jury box, as well as a general view of the courtroom from the counsel tables to the witness stand. Sounds like the court's giving a lot of direction to me. No image of the courtroom or any space within shall capture images of members of the public attending the trial, such that their identities could be determined. No camera shall take any close-up of counsel table, such that any detail of any written document or photograph can be identified. This is partly to protect attorney-client privilege, by the way. Based upon witnesses list, there is no restriction regarding showing the faces of any witness during their testimony. The cameras shall not capture or broadcast any images of the jurors' faces, whether during jury selection or during the trial. Particular care must be exercised the day of jury selection. At the beginning of the process, potential jurors will be seated in the gallery and the jury box. The media are prohibited from beginning any recording or live stream until after the entire jury panel is seated in the box and in the gallery. In that way, no faces will be recorded as they move into their seats. If it becomes necessary to excuse jurors during the process, the media are to focus their cameras on a neutral place within the courtroom so the juror is not recorded as he or she gathers items and begins to leave the area. Further, once a new juror is called come from the gallery, the camera must remain focused upon a neutral space, so the face of the new juror is not recorded as they move into the well of the courtroom and to their seat. As determined by the court and in response to the pretrial motions, the live streams of court proceedings are not to include anything which occurs within the courtroom, but outside the juror's presence. Whenever the juror is excused from the courtroom, the video feed of any live stream shall be stopped in order to ensure the jury is not exposed to anything which happened within the courtroom during their absence. Once the jury is reseated, the live stream may resume. The media shall not record or live stream an image that shows the faces of the jury during entry to or exit from the courtroom. Should the court engage in individual voir dire of any or all prospective jurors, that will be conducted in this particular courtroom. That courtroom and process will be open to the public and media. However, neither still photography nor video recording will be permitted. So in that courtroom, no recording devices, but media can still be there. The court finds that use of such equipment carries too much potential to be detrimental to the process, and permitting cameras is unnecessary to fulfillment of the need for public access. So, one of the reasons I say that their right of authorship is dubious, because the court is dictating so much of this. You will shoot from here. You will shoot these things. You will not shoot these things. When this happens, you will aim your camera here. When this happens, you will aim your camera there. When this happens, you will have no camera. So a lot of this seems to be coming from the court. Now, what makes that interesting? It's twofold. It makes it interesting. If this is totally a work of the court, then it's a work of the government. And copyright seems impossible. But let's be slightly more generous. Let's say that it is partially a work of the court and partially a private work. Now, without an agreement to the contrary, under basic principles of copyright law, ownership of such a joint work is owned by both parties, fully and completely. Each party owns an undivided joint interest in the copyright, which means that to the extent that the court is a partial author, or joint author to be used more properly, the court has a complete copyright interest in the work, which is the government. So that kind of, swallows law and crimes ownership interest. Incidentally, on a purely technical level, I think Rackets owes me money because I'm a joint collaborator of his work without an agreement, but I'm doing it for the exposure. So that's fine. We have fun. All right, so yeah, not so much. Then we can take a look at this similar order from Rittenhouse, the Rittenhouse trial. Kind of similar, a little bit longer. We won't read the whole thing. Here's how many people will do. Here's how many people selected. Here's where they will be seated. Here's when they will be seated. Public seating, public entry. Here's where the media will be seated. How cell phones, computers, and then they have courtroom coverage for the Rittenhouse coverage. 3 cameras provided by Court TV. It says who will provide them in this case. Will be permitted to be mounted in spots deemed acceptable by the judge. Judge is author. A switcher will be permitted in the back. The cameras will be subject to any restrictions set by the court. In case of a disagreement between the media coordinator shall consult with the judge for determinations. Unless otherwise prohibited by the court, live coverage shall be permitted except during jury selection. Neither Court TV nor any other media copy outlet will hold copyright or any other intellectual property for any raw footage for cameras. No copyright. So an explicit term in this Rittenhouse agreement, perhaps an implied term by the nature of the agreement in other agreements, in whole or part. Here's an email about the Edgecombe trial. In the case of the Edgecombe trial, asking, I was wondering if there's a pool footage, and someone saying Court TV is the pool camera. I hope that helps. So, in the case of the Edgecombe trial, yeah, pool footage. I think law and crime might be bending the truth substantially when they say they're not pooling footage, since it seems like the nature of the orders are for pooled footage, to my mind. All right, so let us finish the stream with some legal analysis. Now, I'm going to try to do this as fairly as I can, right? Which I think is, in the interest of legal education. We're going to read this and try to see what it's trying to say. But I want you to read, I want you to see the underlying decision. That makes me a good legal educator, right? I've offered some opinion along the way, to be sure. And I'm going to share with you the underlying opinion from the Supreme Court, which is the law, to help you maybe form your own opinions. But here's what I think going in. I think that their claim is dubious at best. It's not clear to me it's their camera. Even if it is, it's not clear to me the person behind the camera can be said to be making any creative decisions. Even if they are, those decisions seem to be in large part dictated by either the reality of the situation or by the court. So the copyright interest seems to be deeply questionable. And then, assuming that there is a copyright interest, You then go into a fair use analysis, and commentary and education are classic fair use purposes of a thing that's a public trial that the public is paying for. And you're giving it open access. So, you know, I think you're kind of well within the fair use analysis, assuming you get that far. But let's talk about the issue of the copyright. Let's talk about whether there is an underlying copyright. And to do that, we're going to go to Feist, which is the most relevant case on point. So what you need to know about Feist is it's one telephone book copying another telephone book. Back when telephone books were a thing, which apparently was still a thing in 1991. One telephone book is copying another telephone book. And there's some sadness about this, and we're at the U.S. Supreme Court. So let's read some key things that will help. And this, again, goes to, because a phone book is a factual work, right? It's a collection of numbers. It's a collection of factual work, right? It's not creative. The underlying content's not creative. The underlying content of the phone book is not creative. It's factual. Just like the underlying work of the trial is not creative. It's factual. So I think this case is kind of on point for that reason. All right, so let's see what the Supreme Court has to say, and I need to readjust the margins slightly. So let me do that real fast. Okay, so this is Feist. This case concerns interaction of two well-established propositions. The first is that facts are not copyrightable. The other, that compilations of facts generally are. Each of these propositions possesses an impeccable pedigree. That there can be no valid copyright in facts is universally understood. The most fundamental axiom of copyright law is that no author may copyright his ideas or the facts he narrates. No copyright in ideas. No copyright in facts. Copyright, if at all, exists in expression, not facts, not ideas. There is undeniable tension between these two propositions. Many compilations consist of nothing but raw data. That is, wholly factual information not accompanied by any original written expression, which might be very well true for a trial, right? It's factual, and there's no underlying written expression. You know, it is a reality that's just playing itself out. So on what basis may you copyright such a work? The key to resolving this tension is in understanding why facts are not copyrightable. The sine qua non of copyright is originality. To qualify for copyright protection, a work must be original to the author. Original, as the term is used in copyright, means only the work was independently created by the author and that it possesses at least some minimal degree of creativity. These elements are not obvious in this particular fact pattern. For a particular work to be classified under the heading of writing of an author, the court determined originality is required. The writings which are to be protected are the fruits of intellectual labor, embodied in the form of books, prints, engravings, and the like. So in the context of court TV, where is the intellectual labor, right? The intellectual labor, the creativity, right? Not where's the hard work, not where's the expense, you know, not we had to hire the staff, we had to pay for the cameras, we had to pay for the broadcasting, you know, none of that. Where's the intellectual labor? Where's the creativity for the copyright? $50 from Eric Allen. Thank you very much. I wish you were on when I was on Nick's stream last week, Kurt. You know so much and remind me of one of my best friends who also named Kurt. Yay. I want to show my love. I hope your move is grand. Thank you. I hate moving and I appreciate your super chat. In Burrow Gillis, and $50 is very generous. Thank you. In Burrow Gillis, the court distilled the same requirement from the Constitution's use of the word author. It is a constitutional requirement. The court emphasized the creative component of originality It described copyright as being limited to original intellectual conceptions of the author. Where is the intellectual labor in what is happening in these courtrooms? The existence of those facts originally, of intellectual production, of thought, of conception. Where is the work of authorship? No one may claim originality as a fact. This is because the facts do not owe their origin to an act of authorship. This is because the trial does not owe its origin to an act of authorship. This is because the witnesses do not owe their origin to an act of authorship. This is because the judge does not owe its origin to an act of authorship, and so forth and so on. The distinction is one between creation and discovery. The first person to find and report a particular fact has not created the fact. They've merely discovered the existence. The discoverer merely finds and records, does not create. The mere fact that a work is copyrighted does not mean every element of the work can be protected. Originality remains the sine qua non of copyright, which means but for, or to put it in more direct translation, that which without, the but for. It remains the essential aspect of. It is the foundation of. Originality is the basis of copyright. Copyright protection may extend only to those components of a work that are original to the author. Where are the components that are original to the author? Where is the author? Where are the components? This inevitability means that copyright in a factual compilation is thin. That's where the concept of thin copyright comes from. It's actually in the case law. The copyright is thin. It's a proper legal term. Notwithstanding a valid copyright, which, we're still debating here, a subsequent compiler remains free to use the facts contained in another's publication to aid in preparing a competing work, so long as the competing work does not feature the same selection and arrangement. But here, a question might be, did Law and Crime even have that much? Did Law and Crime even have as much as selection and arrangement? Did they? I mean, the phone book did, right? Because they have different sections for different kinds of businesses. If anyone ever used a phone book before. And those might not necessarily be the same from phone book to phone book. And sometimes they have different kinds of pages. There's the yellow pages, the white pages, the blue pages, and there's some other kinds, I think, too. And, they can be organized differently in different fonts and different headings and different sizes and bold and italicized in all kinds of ways. I mean, the underlying factual information is still there, but the arrangement maybe. But in court TV land, do you even have that much? Do you even have selection and arrangement? You didn't get to determine what order the witnesses went on. You didn't get to determine how those witnesses testified or what objections came when. You didn't get to select them or not. Did you even have that much court TV? Did you even have as much as selection and arrangement? You may, in fact, be less creative than a phone book. As one commentator explains it, no matter how much original work authorship the work displays, the facts and ideas exposed are free for the taking. The very same facts and ideas may be divorced from their context imposed by the author and restated or reshuffled by second comers, even if the author was the first to discover the facts or propose the ideas. So even if Law and Crime was the first to discover it, it doesn't matter because discovery is not enough. How tall is Kurt? Kurt is 6 foot. It may seem unfair that much of the fruit of the labor may be used by others without compensation. As Justice Brendan has observed, this is not some unforeseen byproduct of the scheme. It is the essential element of copyright. The primary objective of copyright is not to reward the labor of authors, but to promote the useful arts and progress of science. So this section, when it talks about the fruit of labor, is talking about a very old idea. All men dating up to 6 foot plus this country. That there's such a thing as sweat of the brow. Sweat of the brow, right? A man is entitled to the sweat of his brow. Perhaps an American saying, right? Entitled to the just reward of his labor. By the sweat of his brawn, he gains a property interest, right? This is some really old school origins of property shit over here, like some Locke shit over here, right? Well, not so much on copyright. We rejected that premise long, long ago when it came to copyright. We rejected sweat of the brow. Sorry, not so much. We reject the argument completely. The Constitution rejects the argument. The Constitution says the purpose: to promote the progress of science and the useful arts. That's the reason. And that's what we're honoring: the promotion of the science and the useful arts. We don't care how hard it is. We don't care how expensive it is. We don't care how much effort it took. We don't care what kind of staff you had to pay. Copyright does not rise or fall on any of these things. Sweat of the brow is irrelevant. Don't care how hard it was. Don't care how much money you spent. Don't care how diligent you worked. Copyright does not turn on this. It turns on authorship of a new work, of promotion of the sciences and useful arts. That is the nature of copyright. Decisions of the court applying the 1909 Act made clear the statute does not permit a sweat of the brow approach. In the decision International News Service of 1918, the court stated unambiguously that the 1909 Act conferred copyright protection only on those elements of a work that were original. Recognizing Section 5 of the Act specifically mentioned periodicals including newspapers, the court acknowledged that news articles were copyrightable. It flatly rejected, however, the notion that the copyright in an article extended to the factual information it contained. The news element, the information respecting current events contained in the literary production, is not the creation of the writer, but is a report of matters that ordinarily are public juris. It is history of the day. A news article might have some creativity because an author has to write it, but reflects an underlying factual reality that is not protectable. So a news article may show some creativity. Where is the creativity in these courtrooms? It isn't in the lighting. It isn't clearly in the placement. It isn't in the witnesses. It isn't in the judge. The lens choices seem kind of dictated by the nature of the situation. The audio isn't creative. You know, where is the creative work? Where is the intellectual labor? Not clear, to my mind. The 1976 Copyright Action deleted the prior section and replaced it with 102B, which identifies specifically those elements of a work for which copyright is not available. In no case does copyright protection for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it is described, explained, illustrated, or embodied. Section 102 is universally understood to prohibit any copyright in fact. Any copyright in facts. And those are the sections of Feist that I thought were most relevant to share with you. And arguably, there is more work of originality in a phone book than there is in what Court TV does. A phone book is compilating facts, but how they're arranged on the page, or how big the pages are, or what font they use, or spacing, or bold, italicized, section headings, illustrations, pictures, ads, what kinds of sections, what kind of pages, white, yellow, blue, right? There are some creative choices in a phone book. And there's arguably, to my mind, more creative choices in a phone book than in this courtroom. Not controlling the witnesses, not controlling the judge, not controlling who speaks, not controlling when, not controlling the flow of that speech, not controlling the audio, not controlling the lighting, not controlling the camera placement, not controlling the number of cameras, not controlling what you can see and what can be shown and when. You know? Editorial decisions, to the extent they exist, seem well driven by the underlying facts, because you're going to point your camera at the witness when the witness is talking, because of course you are. So where is the creative aspects of this to form the underlying copyright? And the answer is, it's not obvious. It's not obvious. So, you know, that's kind of the issues there. And if I said, so, because someone said I said a Court TV when I said Law and Crime, I might have flipped it backwards and forwards. It wouldn't matter either way. If I said Court TV, it might have been because they were on my mind, because one of the court orders specifically mentioned them by name. But it wouldn't matter either way. It would be the same thing. Just, you know, substitute one for the other. It's the same exact analysis. You know, if I, you know, where's Law and Order's creativity, or where's Law and Crime's creativity? Where's Court TV's creativity? Where's, you know, any of these people's creativity? Where does it exist? It's the same question. So if I accidentally used one name instead of the other, then I apologize, but it makes no impact on the ultimate legal analysis. So that's kind of where we are sitting on all that. And then, of course, assuming that there is copyright, you still have the fair use analysis. So let's just look at that real fast. Let me just download that real fast so we can talk about it. You know, it's always good to have these things, I think. So let's just download it real fast and take a look at fair use. And do a little back of the envelope fair use analysis. That might be fun. All right, let's take a little look at 17 U.S.C. 107, fair use analysis. Okay. Notwithstanding the provisions of Section 106, which says you have a copyright if you're an author of an original work, the fair use of a copyrighted work, including by reproduction of copies or phonorecords or by any other means specified by that section, for purposes such as criticism, comments, news reporting, teaching, scholarship, or research, is not an infringement. Now, to my mind, Nick's channel fits the first couple of those pretty easily. Can what Nick's doing be thought of as criticism? Yeah. Is it commentary? Yeah. Is it news reporting? Yeah. Is it teaching? Yeah. I mean, those purposes seem like purposes that Nick is accomplishing. And it's not an infringement of copyright. So Nick seems to be falling within 4 of the explicit purposes of fair use. Well, that's a pretty good start. I mean, you don't necessarily need any of them, incidentally. They're just examples, so you don't need any of them. But hitting 4 out of 6 isn't a bad start. In determining a work in any particular case is fair, the courts shall consider the following factors: the purpose and character of the use, including whether it is of a commercial nature or is it for non-profit educational purposes. Well, this is a commercial work, I think. I mean, Law and Crime is making money off of it, and so is Nick. But then again, there is also the educational purpose, although not a non-for-profit one. But, you know, this one is probably more on the commercial nature. Maybe not 100% commercial nature, but more on that end. The nature of the copyrighted work. This is an area where that's a big problem for Law and Crime. The nature of the copyrighted work. When they say the nature of the copyrighted work, they mean whether this is a work of fact or a work of fiction. That's what they mean. Is this a work of fact or is this a work of fiction? And that's a big problem for Law and Crime. This is a work of fact. Right? The nature of it, and it's even kind of worse than that in some ways. It's arguably worse than that because it's not just any work of fact, mind you. It's a work of fact created by the government. And it's arguably even worse than that because it's not just any work of fact created by the government. It's a work of fact that is constitutionally compelled to some degree. You know, the right of a trial is publicly required. You know, video cameras may as such not be required, but the nature of the underlying work, I mean, its fundamental nature, the thing that it's doing is, it's like, not only is it a work of fact, not only is it a work of the government, not only is it a government created work in some sense, but it's a constitutionally mandated government created work. And the nature of the work and it's being exposed for public use, I mean, fills a fundamentally public purpose. So, you know, on the nature of the copyrighted work element, and Law and Crime's not looking that great here. Not a lot great there. The amount of the work, Law and Crime probably has that in spades. Nick is using the work in its whole or substantially there too. He's using the entire, well, that's not strictly speaking correct because he always cuts out the commentary. So he's not strictly speaking using 100% of the work. He might be using 90% of the work. I don't know. I've not done the hard numbers, but he doesn't do the commentary. And sometimes he cuts out the breaks when they're looking at nothing. So let's say he does 90% of the work or 85% of the work. So he uses a large amount of the work. And then number 4, the effect and use on the potential market or value of the copyrighted work, which to my mind is in some ways Nick's best element. Because how much does chat in Nick's chat tell Nick and the rest of us to shut the fuck up? How much do they keep telling us to shut up? They just want to hear the trial. They say it all the damn time. They literally say it all the time. Go read any of Nick's chats. Go read any of them. And you'll see every time someone talks, they'll be like, shut the fuck up. Stop talking so we can hear it. Right? Well, we're obviously disrupting the work enough that people are noticing. Hey, I just want to listen to the trial. I don't want to listen to your crap commentary. Right? So what Nick is doing is therefore not a substitute for what Law and Crime is doing. Right? It's not a substitute for the work. It is not, in fact, the case that watching Nick's channel would serve as a replacement for watching Law and Crime, as Nick's own chat repeatedly chastises us. Shut the fuck up so I can listen to the trial. We're like, fuck you. We're doing what we want to do on our channel. We are not, in fact, a market substitute. So, you know, there's that. So Nick is looking pretty good on these fair use factors. He's got 4 of the 6 fundamental purposes of fair use. He looks pretty good on the nature of the work. And he looks pretty good on the substantiality of it and whether or not he's transformative. So assuming there is a copyright, which is by no means assured for the reasons that we've talked about, but it's possible, always, it's possible. You know, it's a legal question. But assuming there is a copyright, it's a thin one, and the fair use analysis seems to go the other way. So I think law and crime has problems. These may or may not be surmountable problems in a court of law. Someone else may have differing opinions about these elements. But, you know, those are my feelings on this issue. I think Nick is, and there's still ultimately at the end of all that sort of the big meta point of why don't you just do your own show and make it better? Just drive. I mean, law and crime, you obviously see there's some sort of market desire for what Nick is doing, don't you? I mean, you can see that. There's a market desire for that. So you could just, you know, outcompete him. Offer your own show. You know, with blackjack and hookers or whatever. So, all that stuff. So, you know, that's where we are. So it may in many ways be the case that that this looks a little thin to my eye. And it'll be interesting to see what steps, if any, law and crime takes next. If they saber rattle any harder, Nick can always file declaratory relief, which would be hilarious. Technically speaking, I think you could file declaratory relief right now if you really wanted to. This is probably substantial enough that he could if he won for the lulz, but he doesn't want the lawsuit, which is fine. Maybe law and crime could just stop sucking. So, is Nick's chat evidence in court? Yeah, absolutely. Sure, why not? Yeah, why not? Why wouldn't it be evidence in court? It is because it's real-time perception from people as to whether or not Nick's is a market substitute. It's real-time, spontaneous opinion from people as to whether or not Nick is in fact a substitute or not. So yeah, sure, why not? Why not? You know, here's a chat log. Here's what people are saying on that chat log. You know? Here's people's real-time perceptions. Present sense impression. If we want to go through hearsay exceptions, right? Here's people's present sense impressions. Why not? Works for me. And you go from there. So, sure. So let me read a couple super chats and see where we are. See if, yeah, make sure I acknowledge all the ones that are new. $2 from David Wellman. Long day work, hitting the hay, thanks night. $5 from Clownword. I think you're getting thirsty. Cheers. $20 US from CC says, show us your plus exclamation pluck plus dollar sign. No, I don't think anyone wants to see that. Homestead Dream says $4.99. If there's more than one camera angle in the live stream, it has to be pooled. One camera angle, one camera. 3 camera angles, 3 cameras. And $50 US from Eric Allen. I wish you were on with Nick's stream last week. You know so much and remind me of one of my best friends who's also named Kurt. I want to show love. I hope your move is grand. Well, thank you very much. Thank you very much. So I'm going to head off the stream for now. And I'm going to go yell at Matt again a little bit about the bot. If you've been enjoying the stream, please remember to like and subscribe and do all the YouTubey things. I've been Uncivil Law. I hope all is well. Cheers and good night.